good afternoon to everyone. Buenas tardes, buenos días, y buenas noches a todos y todas. We welcome you to the Rule of Law Webathon Week, organized by the American Bar Association International Law Section, the International Association of Young Lawyers, IABA, through its Human Rights Committee, the Institute for the Rule of Law of the International Association of Lawyers, and the Inter-American Bar Association that we have the honor to represent. This panel, a Rule of Law Webathon presentation hosted by the Inter-American Bar Association, is about combating human trafficking and modern-day slavery through the rule of law. It will focus on the challenges and possibilities to fighting human trafficking through the rule of law. A strong rule of law system is crucial for combating and eradicating forced labor, so-called modern-day slavery, and human trafficking. According to the International Labour Organization, almost 50 million people were the victims of such exploitation in 2001. And about that and the statistics, I like to say that, statistics will vary, and this is very well known and underreported crime. So that's just for a reference, but I always say about this, we shouldn't be seeing this in terms of a statistic, because one victim is one too many. It's really a violation of fundamental human rights. Our panelists will discuss efforts being taken by the legal community to strengthen global, national, and local norms and institutional capacities to combat these crimes and impunity, and get justice for victims. Learn how lawyers are working, on their practices in global supply chains, and how you can become involved in initiatives of bar association and other organizations to help in this fight through prevention, protection, prosecution, and partnerships. The rule of law is society's legal underpinning, guaranteeing human rights and creating economic opportunity and development. And we lawyers are often the first line of defense against efforts to undermine, circumscribe, or defeat or weaken the rule of law. The rule of law is our core value. However, it's not merely the stock and trade of lawyers. It takes the whole global village really to strengthen the rule of law at the global level. The universal commitment of the world's lawyers to the rule of law motivates and energizes these projects, and we are proud to be part of it. The United Nations has recognized that trafficking in person is one of the most egregious violations of human rights, as we mentioned. And according to the UN Palermo Protocol, human trafficking is the recruitment, transportation, transfer, harboring, or receipt of people through force, fraud, or deception, with the aim of exploiting them for profit. Men, women, and children of all ages and from all backgrounds can become victims of these crimes, which occurs in every region of the world. The traffickers often use violence or fraudulent employment agencies and fake promises of education and job opportunities to trick and coerce their victims. Needless to say that during the pandemic, this problem that was already a great problem really exacerbated. There were, due to the crisis, a lot more people vulnerable, to this crime and to these schemes. And needless to say that technology, though it has very good uses, it's also, unfortunately, used for, committing crimes. And a lot of the recruiting kind of happens also online, and more so during the pandemic, according to a UNODC report. And that would be even sort of intuitive, isn't it? But the report actually researched a lot of aspects that the pandemic brought in this situation and how it really exacerbated the problem. U.S. Secretary of State Antony Blinken introduced the State Department's 2022 Trafficking in Person report, highlighting how human trafficking affects us locally and globally, and the need of concerted efforts to combat human trafficking. He stated that everyone should be free, and yet through force, fraud, and coercion, human traffickers violate the most basic rights. And traffickers' exploitative practice affect every country in the world, including the United States, by diminishing and destroying our communities' sense of security and the global economy. Well, it was, I mean, you can find the report online, but it really has very valuable information. And one of the things that, the report does also is sort of ranks countries in terms of their, efforts to combat this crime. And we have our keynote speaker, Mr. Chi from Taiwan, given the fact that also Taiwan is a country that is in tier 1 of the State Department TIP report, Trafficking in Persons report, and he will illustrate us as the work and efforts in his country to, combat human trafficking. Unfortunately, he had not been able to join us in person today, but our, own Ken, he will read his presentation and share his PowerPoint. I just want to also sort of emphasize that the existence of trafficking in person or modern slavery indicates that the rule of law, I mean, you could say it's absent in some places, but in any case, it is weak or at least threatened in many countries. And though this crime really targets the most vulnerable and take advantage of the poor, it happened in rich areas too, because sometimes they are the ones who have the resources to, sort of exploit people or benefit from that exploitation, which is really sad that at this point of the 21st century, we are in that situation. Without more, I would like to only mention a few things that the UNODC report mentioned of the effects of the pandemic to give, the floor to Lisette. More situations of vulnerability created, less opportunities for victims to seek help and support, more difficult to detect victims of TIP or trafficking in person, closure of borders making responses more difficult, the recruitment moving online, as we mentioned, and exploitation also. So those are a few of the findings. But without that, I just want to thank you all for attending and thank all our panelists for really kindly agreeing to participate in this panel. We have a really great panel, diverse in all senses, in terms of knowledge, approaches, gender, and regions of the world that they represent. So we are very honored to have you here with us. I would like to introduce our dear Lisette. Lisette Robleto de Howard is currently teaching associate for the Law for Manager course at UCL's School of Management. She was Chief Programs Officer at Advocates for International Development, A4ID, until March 2023. Before that, she was International Programs Manager at the Law Society of England and Wales, where she created and led the implementation of the International Rule of Law programs. In 2022, she helped set up the new Global Compact and Forum for SDG 16, which we give them credit for being very active in that and also engaging us on that project. I mean, she has a lot more experience than what I could represent here, but for the sake of time, we will give the floor to Lisette and thank her for her incredible help organizing this panel. Thank you.
Thank you, Lourdes. Welcome, everybody, the participants, the speakers, our keynotes. A warm welcome to you all. And thanks to Lourdes for not only for her kind invitation to help me moderate this and to help moderate this webathon and this particular panel, but also for her always welcoming remarks. And so thank you for those words, Lourdes. Just to emphasize the context behind this particular session, this is the 5th of 9 sessions of the 2023 Rule of Law Webathon. This is the 3rd concurrent year that we've been running this particular week-long series of seminars in order to illustrate the link between the rule of law and the wider thematic agenda. But most importantly, what we are trying to do here is trying to highlight how the legal profession can influence and be a force for change. And on that regard, I think we had several sessions before that have been absolutely enlightening in terms of the topics that they have covered. Today, as Lourdes rightly expressed, we are going to be focusing on human trafficking. And we have a fantastic lineup set of speakers and looking forward to the conversations today. Given that Mr. Shi is not going to be here, I just wanted to briefly introduce him as our keynote. He's LLB from the Department of Law at National Taiwan University. He was Chief of First Section, Department of Medical Affairs, Ministry of Health and Welfare between 2012 and 2013, in charge of regulatory affairs. Then he moved to the National Immigration Agency of the Ministry of Interior as the Director of the Chief of Section of Mainland Affairs between 2013 and 2015, before his service at the section of the anti-human trafficking in the agency. Throughout his civil service career, he has experienced cross-border issues, fire protection, government procurement appeal review, internal affairs regulation, legal research, and local clean government business. As you can see, his wide range of experience makes him a fantastic keynote. Briefly, just before I hand over to Ken, who has kindly offered to present on Mr. Shi's absence, I just want to explain very briefly the modalities of today's session. We will have the keynote. After the keynote, I will be introducing all the panelists. And following their presentations, we will have a Q&A, and that will end with closing remarks from Lourdes. The floor is yours, Ken. Thank you.
Thank you, Lisette. Good morning and good afternoon, everyone. I'm Ken Wu, an extern of the Inter-American Bar Association, and it is really an honor to be here presenting the keynote speech representing Mr. Chengping Shi. And the following speech will be presented in Mr. Shi's first-person tone. So let me share my slides here first. Yeah. Okay. So can you see my slides here? Okay. So to start with, Mr. Shi is introducing himself, and he said, I am the section head responsible for the human trafficking prevention affairs under the National Immigration Agency, NIA, Ministry of the Interior of Taiwan. And it is an honor to have the opportunity to be a part of this meeting and discussion. I want to start from the statistics, and then I will go into the legal aspects regarding combating human trafficking. The materials shown in this presentation is based on my personal experience and perspectives, with thoughts and approaches I would like to share with you. And it does not constitute official comments by the Taiwanese government. In addition, the figures and phrases used in this presentation were excerpts from the US Department of State annual TIP report. Search results of online news, media, and chat groups, and the internally maintained data by the government departments. Some of the contents and statistics were originally published in English and were translated into Chinese. Possibly discrepancy or gaps may exist due to the insufficient understanding or lack of precision in translation. I appreciate your understanding, as my hands are tied with my daily duty and I don't consider myself versed in the English language. My presentation for this meeting will be dictated by the extern of the IABA, Mr. Ken Wu. Your understanding will be appreciated. Yeah, so, okay. So as you can see, I will divide my presentation into 4 main parts for your perusal, including the first part, the emerging of human trafficking trends, and also the second part, international and national data on human trafficking, and the third part, the regulations on prevention of the human trafficking in Taiwan and other countries. And number 4, the speculation of the conjectural consideration and linkage. Okay. So to start from the first part, so the forms of exploitation and human trafficking that are familiar to most of you in this meeting and as defined in the protocol to prevent, suppress, and punish trafficking in persons, especially women and children, published by the UN in 2000, include forced labor, sexual exploitation, and the removal of organs. In Taiwan, forced labor is habitually referred to as labor exploitation. However, the biannual report of UNODC finds in the latest 4 years that suspects using or forcing others to commit crimes has become a new major form of human trafficking. So far, those crimes have involved pickpocketing, drug abuse, drug trafficking, and growing plans for the use of drugs. UNODC points out in its 2000 report that this form of exploitation constitutes 4% of the total human trafficking activities. In its 2022 report, the portion has climbed to 10.2%. Besides, Directive 2011-36 EU of the European Parliament and the Council, which is issued on April 5th, 2011, has long listed exploitation of forced criminal activities as a form of human trafficking. Okay, so we shall then take a look at the statistics from the perspectives of international organizations. And in September 2022, the ILO reports 50 million people being subject to modern slavery, including forced labor and forced marriages. And 2.76 million of the reported are under forced labor. There is an increase of approximately 9.3 million people under modern slavery comparing to the previous report made in 2016. The number of people under forced labor alone had increased by 6 million since 2012, and the source of data after 2016 were International Labor Organization Walk Free Foundation, which is a human rights group for the elimination of human trafficking, and the International Organization for Migration, the IOM, while the statistics were compiled using all three sources combined. Okay, so besides from the statistics released by the international organizations, another important source of data is the US Department of State annual TIP report. Okay, so I need to make something clear about this specific TIP report beforehand. As you can see, the charts I use in this presentation show the years of the reports as they were issued. So generally, this TIP report is released in the month of June every year. So the report actually contains data that depicts events taking place in the prior year. So for instance, the data in 2022 over here reveals the state of the year of 2021. So also in 2020, the COVID-19 pandemic loomed large all over the world. So, but in the following 2 years, the data on trafficking victims as reported by the listed countries in 2021 and 2022. So in general, shows no significant rise or fall. So, okay. The pandemic did not seem to have a great impact on the government or private organizations' efforts to rescue trafficking victims. The rescue efforts referred here to include the victim identification conducted by or funding provided by the government authorities. Also, in addition, countries covered in the TIP report inevitably differ in terms of their anti-human trafficking laws. Substantial differences surfaced in comparing the counts of rescued victims between countries, as we can see in the numbers of rescue victims per 100,000 population. Let's take UK as an example, has a ratio of 18.9% from the most recent year in the report. So the chart enables us to make a reasonable connection to that UK has the broadest scope of regulatory coverage with regard to the protection and rescue of victims. So it has the highest count of the rescued victims, as you can see here, 12,727. Okay. So let's take a look at the next chart here. So this chart has the statistics on indictments and convictions. So the number in the cells refer to headcounts. So due to the complexity of criminal trials and often years are needed to see the verdict, I think it is difficult for countries to track the numbers in terms of case count. So as you can see, some of those are here, like we have a Chinese character here, which means case. And some of here, we have a Chinese character here, means people, okay? So also like the earlier thing Mr. Xi just talked about is also the situation in Taiwan. So in juxtaposing the chart of the suspects and the chart showing the victims, please recall the fact that the count of the rescued victims is high, whereas the number of the indicted or convicted suspects are low. It seems to reveal that the great difficulties and challenges that lie in the prosecution of human trafficking crimes. So by saying prosecution, I refer to 3 processes in respective orders. Number 1, upon the completion of police investigation, and the case is then referred to the prosecutor's office, and then the prosecutor's office decides whether or not to indict. the indicted case goes through court trials, and the presiding judge reaches a verdict of the suspect being guilty or not guilty. Okay. So two main so then we go to this slides talking about the crime correlation data in Taiwan. So two main sources originate the judicial police cases that are referred to the prosecutor's office. Namely, the cases directly investigated by the judicial police based on leads and the cases reported to the police by the victims or by other private parties. We first take into account the way the police force deploys its main power and allocates resources between various criminal cases. The way it conducts performance and goal management, and the fact that it maintains a balanced target score. With all these provided, the police conducts the investigation of criminal offenses of human trafficking. So the case referred to the prosecutor's office have leveled off, whereas the number of indicted suspects have slowly dropped within the past 6 years. When the required elements for imposing criminal penalty to a human trafficking offender, the competence level of prosecutors and judges, and the political and economic trends in Taiwan remain pretty much unchanged. And educated guess seems to be that the achievements of Taiwan's anti-TIP actions have much to do with how much results the awareness campaigns and prevention have brought. The eventual drop of the figures in 2022 is visible because starting from January 2020, the COVID-19 pandemic had continued to spread, and the movement of population across or even within nations failed to go back to normal. So the number of foreigners entering Taiwan and subsequently falling victims to trafficking had dropped drastically. Therefore, in the 2022 TIP report, the number of suspects and cases referred to the prosecutor's office by the police in 2021 witnessed a substantial plunge, and as shown in the brown lines and letters. Yeah. I want to go one step further and make clear that the pandemic brought deferred impacts to 2 years afterwards. Okay. So you may have also learned from internationally disseminated messages that hundreds Taiwanese were scammed to travel and seek jobs abroad in the second half of 2022, only to find themselves falling victims to labor trafficking and being forced to engage in telecom frauds. So due to that event, the number of cases referred to the prosecutor's office by the police in 2022 saw significant growth. There were 107 cases in 2021, and as reported in 2022 in this chart here. Yeah, but the case count rose drastically to 161 cases in 2022, an increase of 54 cases. So 320 suspects were indicted in the same period, and this is a huge increase of over 200 suspects comparing to 2021. The 2022 statistics will be shown in the US Department of State 2023 TIP report. So, okay, so various law and regulations work jointly in terms of the human trafficking prevention. Various government agencies, each having a specific realm of competence and being responsible for enforcing a specific set of laws, work in concert to achieve integrated effects and combat human in multiple fronts. So please refer to the slides for details. Okay. So, so in practical cases investigated, indicted, or tried in Taiwan, entities such as institutes providing long-term care or tea factories belongs to unincorporated groups instead of legal persons. The representatives and important employees of such unincorporated groups were found to have engaged in hiring and labor exploitation of legal migrant workers, as well as migrant workers who went missing from their legal employers, due to the fact that such unincorporated groups are similar to legal persons in terms of hiring substantial numbers of employees and having considerable capital. The authorities in Taiwan have produced the draft amendment of law to include unincorporated groups as entities and punishable by fines. Okay, so besides from criminal penalties, another means resorts to non-criminal penalties, depending on the nature of the businesses under the brokerage, to set restrictions over private parties with high security concerns or high risks of involvement in human trafficking. Restrictions may be that of whether one can take the profession of doing a certain business or one can continue operating an existing business. So for instance, a natural person convicted of human trafficking crime is prohibited from taking a job in private placement service, immigration service, matchmaking service, security company, or other businesses. In addition, the administration sector may take discretion to cancel the permit of a business or issue an order to close a business. The owner, business operator, ship captain, or a flight captain involved in transporting victims in human trafficking may be ordered to cease practice the trade for a certain period or even face cancellation of one's professional certificate. The variety of means of penalty listed herein, being administrative and preventive, requires no final conviction by courts and are launched by the administrative authority based upon its respective authorities and responsibilities. Taiwan certainly has other non-criminal means to deliver penalties. The authority may place restrictions on foreign fishing vessels from entering a port in Taiwan or place restrictions on unregistered nationals, the equivalent of overseas citizens from entering Taiwan. So to be sync with the international trend with regard to human trafficking prevention and to reinforce the social responsibility of business, in the future, when the amendment bill is passed, the natural person, legal person, or unincorporated group convicted of human trafficking crime by a final judgment in court being sentenced to prison terms or fine will be banned from tendering in government procurement for 5 years, according to the draft amendment of Human Trafficking Prevention Act. A foreign natural person or foreign legal person convicted and sentenced to prison terms or fine outside Taiwan will be subjected to the same ban. Such requirement also serves the function a credit check based upon which local private businesses may decide for themselves whether to start or end an ongoing business relationship with the said offenders. Okay, so yeah. So the aforementioned restrictions placed on tendering in government procurement, working together with the trend in supply chain management in other countries, may create a concerted effect. So I will bring up the supply chain issue in later parts of this presentation. So, okay. So For now, this page is about the action plan for fisheries and human rights and in Taiwan. So if you would like to know more about the plan, we are very happy to share with all the audience and the panelists about what's the detail about this plan, and we're happy to share the slides and also the script, maybe a bit about this kind of plan here. Yeah, so we have a comparative law session here as well. Yeah, but yeah, sorry, but okay. So yeah, this is also a comparative aspect from the other countries, like how their legal frameworks are. Okay. So yeah, I think we can talk about this for a bit. Okay, so the nations joined to issue legal or administrative directives demanding businesses to fulfill due diligence obligations or make anti-slavery statements and accomplish through the supply chain the goals of prevention of forced labor, protection of human rights and the environment, and pursuant of sustainable development. Okay, examples are the Modern Slavery Act of the UK, the Business Early Warning Obligations Law of France, and Supply Chain Business Social Responsibilities Act of Germany. So the Commercial Transparency Bill of Norway and the Modern Slavery Law of Australia. So Taiwan, Japan, and South Korea, while all working on specific measures to render the business sustainably fulfill obligations in due diligence, are contemplating on whether to put it into legislation. So please refer to the slides for the fundamental points of interest in the supply chain bill and the conditions for business to put into consideration. Okay. So yeah. So let's take a look at let's take a look at the few more slides here. Yeah. Yeah. So I think I'm taking way too much of time, but yeah, I'll just skip to the conclusion right here. Okay, so we want to take a look at that. The NIA's website has a dedicated section for information on human rights, human trafficking prevention. So please refer to the PowerPoint for the linkage and all the information and materials regarding the aforementioned international conferences on human trafficking prevention. They're both in Chinese and in English, are available through the links we provided, just like earlier. We have, yeah. And at last, this is what Mr. Xi would like to share with everybody. And the perfect rules are still difficult to come by in this world, and we all hope and we'll all work for a better rules and a better future. And when the COVID-19 pandemic spreads, enormous scale of forced anti-labor occurred in many countries, then artificial intelligence solved fast progress. Does that prolong the forced anti-labor phenomenon? This is probably what the world needs us to think about and to figure out for now. Yeah, thank you for your listening.
Thank you, Ken. We really appreciate the great work you had done helping us, to get the confirmed participation of Mr. Xi, and also relaying his presentation. You've done a fantastic work, and I would like to really thank you. It's been a pleasure today, as every time that you've been working, during the time you've been working with us at the IABA. Thank you. Without more, I'd like to give the floor to Lisette Thank you.
Thank you, Lord. Thank you, Lourdes.
Who's also representing the IABA as a senior member. Thank you.
Thank you, Lourdes. So just to recap very briefly to what Ken very well, fantastically presented to us. Mr. Xi's presentation referred to different forms of trafficking, forced labor, sexual exploitation, and removal of organs. There was also a new trend, several new trends identified, but the most sort of striking one is the trafficking for forced criminal activity. And there is also very clearly identified an incremental trend in trafficking, comparing 2012 with 21 million people in forced labor, 2016, 41 million, of which 15 million were in forced marriage. And then in 2020, 50 million of these, 27 were in forced labor, 22 in forced marriage. And then the presentation followed with the case study or an overview of the situation in Taiwan, where it seems that the number of cases has remained stable, but there has been a gradual decline in the number of defendants, which may indicate the effectiveness of prevention efforts. So it is in this context that we will hear now our panelist, Rory Oak, who is a consultant contributing to a range of projects relating to modern slavery and sustainability, developing practical solutions to embed human rights due diligence across supply chains in line with the law and international standards. During his time at the organization ARDEA, A-R-D-E-A, Rory's projects have involved clients in professional sport, finance, IT, manufacturing, and agricultural sectors. Rory recently graduated with a master's in law with distinction from the University of Law. Previously, he earned a history first-class degree from the University of Reading. His decision to make the transition into law was driven by a keen interest in the role that responsible business practices play in eradicating modern slavery. So on that note, Rory, I want to call on your expertise to present us the work of ARDEA International, and so that you can provide us with that overview as well in terms of not only the wider, the broader legislative landscape, but also from the UK perspective. Thank you.
Thank you very much, Lisette. It's great to be on the panel today. I know we've got a lot of speakers coming up, so I'll just jump straight into a quick intro to ARDEA and what we do. So ARDEA is a UK-based consultancy that advises businesses on sustainability and business human rights. Specifically, we do a lot of work on strengthening human rights due diligence processes and have particular expertise in managing risks of modern slavery in supply chains. As you can see from the companies that we work internationally and with clients from across sectors. Clients that we work with vary between those who require support with meeting their legal compliance requirements and others who are seeking to implement best practice due diligence processes in line with international guidance or soft law standards. So the Modern Slavery Act and human rights legislation more broadly is a really key part of the work that we do. And we previously mentioned the Modern Slavery Act a couple of times, and I'm sure people are familiar with the Act, but it was one of the first mandatory human rights reporting requirements to come in and was considered a leading piece of legislation when it was first enacted back in 2015. 8 years on, it has had some impact on the practices of UK companies and it's improved transparency generally, but it has been criticised for not going far enough in holding companies to account, and there have been calls for reform of the law. In the time that I have today, I'll go through some of the ways that businesses, particularly in the UK, have improved their transparency in response to the Act, and also some ways in which the Act falls short and is arguably being left behind by incoming legislation, particularly in Europe. So Section 54 of the Act, which is the transparency in supply chain section, This applies to companies carrying on business in the UK with an annual turnover of over £36 million. These companies are required to publish an annual statement on their website, setting out steps they've taken to identify, address modern slavery risk in their operations and supply chains. As for the information that should be included in the statement, companies are supposed to cover these 6 areas. So the business's structure, operations and supply chains, the policies that are in place relating to modern slavery, the company's due diligence processes, risk areas that it's identified, both within the business and within the supply chain, how the company measures the effectiveness of the steps that it has taken to address those risks, and any training that it provides to its employees. Several benchmarks have been carried out each year since the Act came into force. This particular data here comes from the Financial Reporting Council. The evidence is based on the reporting practices of a sample of 100 companies, I think a mix of FTSE 100, FTSE 250 and some other smaller listed companies. I'd say that these results are definitely reflective of what we see within the companies whose modern slavery statements we benchmark and we've been asked to improve. Most companies will have some sort of policy commitment in place, stating that they respect human rights, or they will endeavour to manage forced labour risks. Even that is relatively low. Only 46 out of the 100 companies were deemed to give us sufficient disclosure in that area. But by far the thing that companies struggle the most with is how they monitor effectiveness. So only 17 out of the 100 companies that were examined provided sufficient information on things like the KPIs that they use, targets that they have set, the monitoring of the steps taken to address modern slavery risks that they face each year. And you can see from the chart overall, none of the reporting requirements see over 50% of the companies providing sufficient levels of disclosure in any of the areas set out in the Modern Slavery Act. And these are larger listed companies in the UK that you might expect to be some of the better performing businesses in the country. I think this is one of the fundamental issues that people have raised with the uptake of the Modern Slavery Act. Most in-scope companies are reporting year on year, but they're not demonstrating continuous improvements, and many of them don't even meet the minimum requirements around the expectations of information that should be included in the statements. So I think when we think about why this is, why so many companies aren't able to meet the expectations of the law and expectations of consumers, there's a number of factors that we've come across that make reporting on modern slavery and forced labour particularly challenging for companies. Some that we frequently hear, for example, are social sustainability tends to take a bit of a backseat compared to environmental sustainability. Many businesses are very focused on their environmental initiatives and carbon reduction targets and things like that, which are obviously incredibly important for a business to have in place, but shouldn't necessarily be the be all and end all where, you know, a company develops a kind of tunnel vision on things like carbon and fails to put resources into managing other aspects of sustainability, like managing human rights risks. Another challenge is the lack of accurate data, because it's obviously difficult to find accurate information on something that tends to be hidden, such as modern slavery, especially as you start to look further down the supply chain. Companies sometimes find that they only have limited tools at their disposal to identify risk, and can show a tendency to over-rely on things like social audits, which aren't necessarily a perfect way of identifying risk, and can lead companies down a kind of tick box approach towards identifying risk, as opposed to using more appropriate measures or cross-checking various different means of identifying modern slavery risks. And then when you start to look, obviously the Modern Slavery Act is a supply chain piece of legislation. So with any supply chain legislation, there's always going to be a limit to how much information you'll have at your disposal and how detailed you'll be able to look through the supply chain, especially when you go beyond tier 1, or if you start looking into these higher risk regions. So companies with suppliers in higher risk regions for human rights might not have a complete view of all of the entities involved in the supply chain, or they might also not be aware of the extent of subcontracting. Companies might not know who the workers in their supply chain are employed by, who is working at the sites that they buy from, which obviously carries its own set of significant modern slavery risks. When it comes to addressing these challenges in reporting and due diligence processes, lawyers and in-house counsel will play a key role in several aspects of it. For example, and I think the most obvious one is probably managing regulatory compliance, but also in terms of procurement, in renegotiating supply contracts and cascading standards down the supply chain, overseeing disclosure and reporting processes, so helping the business to decide how much information should be shared publicly, and then ensuring that all of this information is accurate. So there's no risk of the company greenwashing or blue washing, as in making public claims as to the ethics of the company or its product that aren't accurate. And then finally, creating the proper internal governance structures and policies to embed respect for human rights. We also do quite a lot of work with lawyers and legal counsel. So I just wanted to mention that we have our online training courses, and we have one on supply chain due diligence and how it relates to the role of lawyers. We have the next one in September, so more information on that can be found on our website if you're particularly interested in that topic. So going back to the Modern Slavery Act and its impact in light of those challenges that we've seen, the Act has definitely driven change as one of the first laws of its kind and promoted more conversations around modern slavery within businesses. And it has led some businesses to be more transparent and to look into what's actually going on in their supply chains in a way that they might not have done were it not for the Act. However, its impact has been quite limited and there's been no enforcement action against companies. Companies haven't come under a great deal of scrutiny for having poor statements or for not updating their modern slavery statements to the extent that I think people might have expected. And in some cases, companies have effectively managed to get away with not complying with the requirements of the law. And the fundamental gap now 8 years on is the fact that there's no direct requirement to undertake due diligence, meaning a company can comply with the Act without taking actual steps to identify or address risks, provided they publish their annual report. So if you compare that with human rights due diligence legislation that's coming in now, it shows it to be quite limited. There have been public consultations held by the government and responded to between 2019 and 2021 with recommendations to make these updates to the legislation, which would bring in mandatory reporting criteria. So the 6 areas that you have to report on would be absolute minimum requirements. Introducing a single reporting deadline to make it easier to monitor compliance if all companies report at the same time. And then further details around board approval to be included in the statement, and a central government reporting service, which has actually already been put in place now. So companies can voluntarily put their modern slavery statements online on this government platform. And then it also discussed extending the obligation to the public sector, and further considerations about enforcement and penalties were included. And then following this, there was the Queen's speech in 2022 mentioned that the Modern Slavery Act would be strengthened, and in the same year, the Modern Slavery Bill was proposed, which seek to introduce criminal offences for false or incomplete modern slavery statements, and to establish those minimum disclosure standards, and also introduce a criminal offence for organisations that persist in sourcing from suppliers that fall below certain minimum standards. This has now stalled, so been discussed for the last couple of years since the consultation. The wait for clarity on whether the Act will be updated goes on for the time being. But elsewhere, if you compare the UK with Canada's new modern slavery legislation, which was enacted at the start of this month, it features much more stringent investigation and enforcement with criminal penalties and fines of up to $250,000. It also includes those mandatory reporting criteria, and significantly, it also imposes an import ban on goods made with forced labour. So I think this is probably, you can see how the Modern Slavery Act in the UK now is being kind of left behind as a much less effective law than these new pieces of legislation that are coming in. Similarly, as Canada has this forced labour ban that they brought in with their Modern Slavery Act, lots of other jurisdictions have. So the US is probably had one of the strongest stances towards banning goods produced with forced labour by placing withhold release orders on goods suspected to have been produced with forced labour, and the European Union has also taken steps to follow suit with their proposal for a regulation published last year. In the UK, there have been discussions by civil society to do something similar, and some discussions about bans on products from certain regions, but these haven't come to fruition yet. So maybe another area where Europe will move before the UK. So another significant trend in legislation that may be even more significant is the growing body of mandatory due diligence legislation across the EU. So, for example, the Corporate Sustainability Reporting Directive and the national legislation, such as in Germany and France, which have now been adopted to require companies to conduct human rights due diligence on their supply chains. So the way in which this is going beyond what we currently have in the UK is, of course, the fact that then they won't just be required to report, they'll be required to actually proactively identify and address human rights risks and report on it publicly, which UK companies currently don't have to do. I think this timeline illustrates how much things have moved on since the last significant piece of UK legislation in this area. And these are also laws that generally have much more, much stronger enforcement regimes. And lots of people have argued that these would address a lot of the areas where the Modern Slavery Act has fallen short or come under criticism. People may have heard of there was wide-scale public reporting about the garment factory scandal in Leicester, which is where there were reports of workers who were working in unacceptable working conditions and being underpaid in the city of Leicester during the COVID lockdown, when there were much higher demands placed on the companies for online shopping demands, and workers were discovered to be working in poor conditions. This did have a massive reputational and financial impact on one of the UK companies with supply chains in the area called Boohoo. However, that is, that financial and reputational harm was done, but people have also commented, as you see from this article, that due diligence legislation that goes beyond the Modern Slavery Act might have held them liable. And all these calls to increase accountability to companies have led businesses in the UK to petition for mandatory due diligence in the UK. ARDIA International was one of the 49 signatories of the latest call, coordinated by the Business Human Rights Resource Centre. You can see there are very large organisations calling for it, even though it would impose stricter requirements on themselves. And many of these large businesses are calling for it to bring about a level playing field, because they're companies that are already currently going beyond the minimum reporting requirements under the Modern Slavery Act, and feel that other organisations should actually be held to the same standard as them to bring about that level playing field and bring about a fair kind of universal standard. And just a final thing to share is that ARDIA contributed to the new British standard on managing modern slavery risk, which has now been published this year. It's free guidance, so anyone can go to the BSI website and download it. It sets out a comprehensive guide on how to develop processes to take a risk-based approach to addressing modern slavery, and it's very comprehensive in its coverage. I think it would be useful for companies in all different sectors and different parts of the world. So I'd definitely encourage anyone to have a look if you're interested. And that's all from me. So thank you very much.
Thank you, Rory, and thank you for sticking to time. That was almost perfect by a few seconds. Thank you very much for a very illuminating presentation. And I must say that I was quite struck by what you said in relation to the significance of the role of lawyers and in-house counsels in terms of the variety of ways they can actually play a role, and not only in terms of regulation and overseeing regulation, but also in terms of ensuring that there is no risk of blue washing or greenwashing, which could actually affect the credibility of the system itself. I was also quite struck by the comment that you made in terms of which is very similar from Mr. Xi's commentary, that there are deficiencies in how the legislation is framed, and also that there is still poor levels of compliance, which means that there is still a lot of work to do. But it's quite remarkable as well that there is a growing body of legislation, EU level and other jurisdictions that require companies to be more transparent, because obviously companies are a very significant stakeholder and player in all of this. And on that note, I would like to give the floor to our next panelist, Professor Eric Beale. Professor Beale joined the Bureau of International Labor Affairs at the US Department of Labor in February 2012. He's part of IABA's senior leadership team, working on a diverse set of projects and activities, including supply chain issues across different sectors and submissions under the labor chapters of free trade agreements. Before joining the department, Professor Beale was managing director for corporate responsibility at Person Matz Stella, a global consulting firm. From 2003 to 2006, he was Deputy Washington Director and Senior Counsel of Human Rights First, formerly the Lawyers Committee for Human Rights. Prior to that, he was Senior Vice President and General Counsel at Hohenheim International, a Washington consulting and law and practice. He also served in several senior positions at the US Department of Commerce, including Deputy Under Secretary for Trade Policy and Acting Director of the Office of Policy and Strategic Planning. Professor Beale, I mean, you have such an amazing experience. I wonder whether you could share with us your expertise in this particular area and how you see the efforts in the US moving forward. Thank you.
Thank you so much, and I apologize for taking a second to unmute. I should note, I am not at the Bureau of International Labor Affairs anymore. That finished at the end of the Obama administration in January 2017. So perhaps the bio I sent was outdated. Since then, in 2017, after doing some speaking and writing about these and related issues in the kind of trade and human rights context, at the end of 2017, I moved to the Fair Labor Association, a multi-stakeholder initiative comprised of civil society, universities, and business. And I've been there for the last 5.5 years until today. So thank you for the kind introduction. And I want to apologize in advance. I know I may have disrupted the order of speakers, but I have to depart at 12:45 p.m. Eastern, which is in about 37 minutes. So I know that we're running a little behind. So let me not exceed my allocated time. I really appreciate being part of this panel and the broader Rule of Law Webathon Week. It's really exciting. And I greatly appreciate the Inter-American Bar Association for this invitation, Lourdes, as well as Ken Wu, who this spring has both been an IABA intern, but also a student of ours at Georgetown University Law Center, where I've been privileged to co-teach a course on business and human rights for the past 15 years. What I thought I would do is you've heard two excellent and detailed presentations going into great detail on trafficking, definitions, frameworks, legislative initiatives, and so forth. And I know you'll be hearing from our two additional panelists, even more so to come. I want to step back. I'm not going to go into detail on trafficking and potentially duplicate what you've heard and will hear. I want to talk very specifically about the role of lawyers in addressing trafficking and in so doing advancing the rule of law. And I think as the best way to frame this is, as Ken knows from our course at Georgetown, we asked the students to role play by identifying themselves during different parts of the semester as representing civil society, as representing government, and as representing business and the private sector in their perspectives on tackling difficult business and human rights issues, including trafficking and forced labor. I guess also given my own background that you've heard a little bit about, working at human rights NGOs, working in government from 2011 to 2017 and earlier from 1990 to 2000. And at the beginning of my career working in the private sector, it only makes sense to kind of think about these issues in tackling human trafficking, forced labor, through the different roles that lawyers can and should play. First of all, it goes without saying that everything we're talking about today in addressing the scourge of trafficking owes a great deal to the courageous lawyers and others working with civil society organizations and trade unions all over the world, including in the global South and everywhere where the sources of trafficking are prevalent. These are the people really on the front line who are, in some cases, putting their lives on the line to try to address trafficking and forced labor and operationalize the concepts we've been hearing about. In this country, you have groups who team with partners around the world, like the Human Trafficking Legal Center led by Martina Vandenberg, that do work on all facets of trafficking, from legal advocacy to victim assistance. The Trafficking Legal Center's slogan is, when human trafficking survivors have lawyers, survivors have rights. There are other organizations like Global Labor Justice, Polaris, ECPAC USA, International Rights Advocates, the Solidarity Center, Free the Slaves, and so on. The point is not to list names and probably miss some important ones, but simply to note that in this area, I think more so than with respect to other key human rights and labor rights issues like freedom of association and occupational safety and occupational health and safety, and combating harassment in the workplace, there already is a very strong nonprofit presence dedicated to advancing the rule of law on behalf of trafficking victims and survivors. Lawyers are proving to be important and key advocates for the people who are directly impacted by these practices that you've been hearing about. Secondly, consider the role of government, including lawyers serving in government. I again will focus, to be brief, on this country, the US. When I say this country, where I'm based, I should say. I don't want to ignore efforts made by governments around the world, including in sourcing countries, but just for the purposes of time, just to note, the US government has made, you just heard about some of the, from Rory, about some of the really important initiatives in the UK. In the case of the US, there have been great strides in the past decade compared to where things were, certainly when I came back into government at the end of 2011, compared with today. In terms of government institutions really devoted to fighting trafficking and forced labor and advancing the rule of law, they're so much stronger today than they were just a decade ago. You have the resources and commitments you've heard about briefly and may hear about more of the State Department through the Office to Monitor and Combat Trafficking in Persons, so-called JTIP office, the TIP office, the Labor Department where I worked, the Bureau of International Labor Affairs and Office of Child Labor, Forced Labor, and Human Trafficking, Department of Justice on the criminal enforcement side, Health and Human Services on the victim assistance side, U.S. Agency for International Development, and so on. And all this is integrated through the President's Interagency Task Force and a National Action Plan on Trafficking. But again, the point isn't to just list participants, but to focus on the fact that a real strategy has developed. And in that regard, I would argue that the biggest game changer in terms of combating trafficking and forced labor in recent years through the rule of law has been through the use of trade mechanisms and under the auspices in particular of the U.S. Department of Homeland Security and its Office of Customs and Border Protection, which has legal authority that didn't exist just a few years ago, provided through a critical amendment in 2015 to Section 307 of the Tariff Act of 1930. And I know I'm throwing around a lot of terms very quickly, but this is a provision that has enabled government lawyers to use U.S. trade laws, import laws, to stop the flow of products made in whole or in part with forced labor from entering this country through aggressive enforcement with close oversight from the U.S. Congress, and now supplemented by the Uyghur Forced Labor Prevention Act passed by Congress a couple of years ago that's targeted at global supply chains that have ties to the Xinjiang region in Western China. So there's been, and Ken knows a great deal about this as we've discussed in class, and I know my fellow panelists do as well. For the purposes of time, I won't go into the details other than to say, in my time in Washington, I've never seen this level of dedicated use of trade remedies specifically to target labor rights and more specifically forced labor and trafficking. Finally, and this may be the most challenging and difficult, and I don't know from our attendees, the mix of where they may be serving, but the third pillar has to be the role of lawyers in the private sector, those who are in-house at companies that may be targets of enforcement, but hopefully also are looking to be complying with laws more aggressively and effectively. Those at major law firms based in the US and around the world, in the UK, elsewhere in Europe, and well beyond, global law firms who are in many cases working to develop stronger practices to address all of the issues that we've been discussing this morning, this afternoon. This is really a rapidly evolving landscape of lawyer engagement and intervention, but there are no guarantees. It's in its early days, and it will really be up to all of us individually and through the IABA and other associations, bar associations, to stay the course, focus on the role of lawyers in the private sector and what they are doing consistent with the principles that are set out in the UN Guiding Principles on Business and Human Rights from just over a decade ago. As one example, just a few months ago, a new group called the Business and Human Rights Lawyers Association was established by roughly 30 leading law firms based in Europe, the United States, Latin America, and elsewhere. And I'm really pleased that my co-professor, who Ken knows well, Meg Rogensack, just a couple of weeks ago was named as the executive officer of the Business and Human Rights Lawyers Association to help advance the organization's mission and vision that, as I just mentioned, law firms and business lawyers need to recognize their responsibilities to respect human rights in line with the UN guiding principles. As the framing document of the organization says, these lawyers need to integrate this responsibility into their client services, operations, and activities. Now, that will not be easy. There will be pushback from others, probably even within some of those law firms, who are wondering, what's this new initiative all about? And I'll say one thing about that at the end when I wrap up in just about 2 or 3 minutes. It's a tall order, but I think it also reflects an evolving commitment of private sector lawyers to better define their own role in addressing trafficking and forced labor and other business and human rights issues, and what they can be doing going beyond compliance to develop approaches to respect human rights and to, in turn, impart those to their clients. There are so many initiatives that are unfolding in this area. And I know IABA and other organizations that have been part of this Rule of Law Webathon Week will undoubtedly be playing central roles in the years to come. In doing that, there's a lot of emerging guidance. Again, we don't have time to talk about it in detail today, but for example, John Sherman, who is with the Harvard Kennedy School, affiliated with the Kennedy School at Harvard, and also the SHIFT project that has close ties to the late John Ruggie and the UN Guiding Principles, has written extensively on the roles and responsibilities of lawyers. The International Bar Association has a document outlining in detail the role of lawyers in a changing legal landscape. And the reason, to wrap up, that this is so important today, and in some ways the most challenging of the 3 areas. I'm confident that civil society lawyers will continue to press ahead with their advocacy and litigation and other strategies. I'm confident, at least if the politics are right, depending on the administration, as is the case in any country, who's in charge, that government lawyers will care about advancing the rule of law, especially with regard to forced labor and trafficking. But when it comes to private sector lawyers, as I mentioned, there are competing pressures. And in this country, I think more than anywhere else, I don't see this nearly as much unfolding in Europe and elsewhere. There's now even politically motivated pushback, calls to step back from activities that have come to be known under the umbrella of ESG, environmental, social, and governance. You may have heard about efforts to put pressure on companies not to respect ESG initiatives. And this is going to be a battleground in the US in the coming years. So lawyers are going to be tested, but I think they can play an important role. So, I think through the leadership of the IABA and others, there's going to be a real opportunity to build on this heightened commitment that I've hopefully outlined in my remarks to the rule of law in addressing trafficking, forced labor, modern day slavery, and to be on the side of, with those in civil society, with those in government, and with those in the private sector who are really committed to using their legal talents, their legal skills, and the guidance provided to play an important role in combating trafficking, as this panel has been discussing. I will stop there. Apologies again for having to leave in a little over 20 minutes, but I look forward to hearing from my fellow panelists. And back to you. Thanks again for inviting me.
Thank you, Professor Beale, for such an inspiring presentation, especially on the role of lawyers working at different levels in the different front lines. So it's definitely a call for action of what we can do in order to move this agenda forward. And there are, Professor Beale also made some references to the significance of a wide variety of stakeholders involved in trafficking, including not only lawyers, but non-governmental organizations, civil society organizations, and the role of the private sector on this. And in a wide variety of topics, from providing legal advice to victim support. They are all equally important in order to make sure that all the segments are covered. In addition, one thing that struck me quite significantly was the fact that what he called the game changer, which is the use of trade laws, including providing that experience in the US, where trade laws are used are made in whole or in part, goods made in whole or in part using forced labor are prevented from entering in the US market in order to target the supply chain. And on that regard, the role of the government is very significant, because without that political will, it's very difficult to advance such complex issues that require a multifaceted approach. And I wonder whether our next speaker, Gillian, will be able to talk to us about not only the deficiencies in the modern day slavery, but also in terms of that political will that Professor Beale was referring to. So now I would like to introduce Gillian. Gillian Rivers is a partner in the family law team at Pennington Manchester in London. She advises on all areas of domestic and international family law and has extensive international practice. Gillian is the immediate past chair to the Family Law Committee of the International Bar Association, a fellow of the International Academy of Family Lawyers, and a member of Resolution. She's also chair of the Pennington Manchester Charitable Foundation, which she established in 2017. Gillian was granted Freedom of the City of London in 2016, and in 2018, she was awarded the Family Law Pro Bono Lawyer of the Year for her work on this particular area, especially in the fight against human trafficking and in recognition of the work of the Pennington Manchester Cooper Foundation. She's former panel advisor to Kevin Highland OBE, who was the first independent anti-slavery commissioner, and she is honorary legal advisor to the Santa Marta Group, an initiative of Pope Francis to fight for the global eradication of slavery. Gillian, over to you.
Thank you very much indeed, and good day to all of you wherever you are in the world, and thank you for the introduction. Professor Beale, I was completely struck by your comment about the importance of the bar associations and the work that they do to raise awareness in relation to slavery and trafficking. And it will not have escaped anybody's attention that I'm a family lawyer, and might beg the question, well, what am I doing talking about trafficking? But it was because of my involvement with the IBA 10 years ago, when I was invited by the then president of the IBA to join with him on his presidential task force, which he wanted it to be about slavery and trafficking. And so the seed was sown in my mind about the importance of this topic. I haven't been able to let it go since. For those who know me will know that. Now, modern slavery, human trafficking, it is the biggest crime against humanity, so far as I'm concerned. And although we can produce statistics, we can speak to statistics, the fact is that they are very unreliable. The TIP report referred to by Speaker Ken is a very good source of information. However, in the UK particularly, we have a very unreliable database because we have too many criteria for gathering information. And so we can only ever give a best estimate, at a best estimate on the basis that a lot of crime goes undetected. And whenever I speak about this, wherever I am in the world, and to include England for these purposes, I always say, I promise you that within a 1 mile radius from where we are standing and talking to one another now, there will be instances of slavery and trafficking. I know, and again, Professor Beale has highlighted all the institutions that are working so hard, the NGOs, Martina Vandenberg, not least, she's an absolute star in this field. Civil society, law enforcement, religious. Over the last few decades, people have really tried so hard to raise awareness, to support victims and to deal with the crime. In my view, and I have made my view quite clear to various organizations, I feel that unless there is a very strong legal system, the crime will never really be eradicated because the law enforcement officers can't work in isolation of statute. And I wanted to say, when I spoke about the Modern Slavery Act, our Modern Slavery Act, I wanted to say it in a rather self-congratulatory way, not, I might add, that I had anything to do with the drafting. But as has been highlighted, in actual fact, our Modern Slavery Act 2015 is actually a wonderful piece of legislation, not least because it's the only piece of legislation we have in the UK which consolidates various statutes and various possibilities for people to bring actions and to support and protect victims of slavery and trafficking, and to ensure that the perpetrators are brought to justice. And we have to be wholly indebted to Theresa May, who, when she was Home Secretary, did all she could to ensure that the bill became law. And we were the first country to have a properly designated, dedicated Modern Slavery Act. Australia, we know, has copied, and they very openly spoke to Kevin Hyland about our act. And what they have done is they've taken the best bits of our Modern Slavery Act and they've remedied in their legislation where we got it wrong. And we did get it wrong. But Lisette, you speak about the politics behind it. And the act was not well received in the various stages of the bill passing through the houses. It was not well received because it was considered possibly to offend commerce. And that is why Section 54 that Rory spoke about, the supply chain part of the legislation, was a bitterly fought section within the Act. And in actual fact, the financial limit for the transparency reporting process was set long after the Act had come into force because it was considered to be politically difficult, anti-trade, essentially. So we do have the legislation, and I would like to share some of the main sections of that Act, because without it, we wouldn't have any of the convictions that Ken was able to highlight on his sections from the TIP report, for which I thank him because I haven't got that information to hand. So what have we got? Section 1, a person commits an offence, and this is a criminal offence, this is not a civil act, criminal offence, if they hold another person in slavery or servitude, or they require a person to perform forced labour. And the key to this is that the circumstances are such that the perpetrator knew or ought to have known that they were holding that other person in slavery or servitude or forcing them to work. So that's section 1. Section 2 concerns human trafficking, and a person will commit the offence of human trafficking if they arrange or facilitate the travel of another person with a view to the victim being exploited. Now, I just want to pause there for a moment because we have heard over the last few years extensively about people traveling, making perilous journeys in thoroughly unsuitable boats, particularly to come to England. That is people smuggling. That concerns the provision of a service, typically transportation, or possibly producing fraudulent documents to an individual who voluntarily seeks to gain illegal entry into another country. Now, it's possible that people smuggling can then turn into people trafficking, but these two concepts are often conflated, I'm afraid to say, particularly by the press, when they talk about this issue. They are two separate issues. Now, if the court can establish that slavery and or trafficking has been committed, then a person guilty of either of those offences or both can be sentenced to life imprisonment, that is on indictment. On a summary conviction, the sentence is for a term not exceeding 12 months or a fine or both. The court also has power to confiscate assets, and this provision brought about an amendment to our Proceeds of Crime Act 2002, so that any offence under Section 1 and 2 of the Modern Slavery Act will trigger the confiscation of assets. There are prevention orders, and these are reparation orders, and that is a court will require a person against whom it is made to pay compensation to the victim, and the compensation will be set by the judge, having heard evidence and representations made on behalf of the person. There is injunctive relief, and this is a civil part of the Act, and injunctive relief can be obtained under sections 14 and 23, and these are prevention orders and at-risk orders. But we need to consider also section 45, which is the statutory defence. Now, in an attempt to support and protect victims of slavery and trafficking, the Act introduced this defence, which can be raised by those who, in the case of adults, have been compelled to commit an offence as a direct result of their being a victim, or in the case of children, they have actually committed an offence as a direct result of their being a victim of modern slavery. And this is a very important protection for victims and relies on the international principle of non-punishment. There is a distinction between the way in which adults and children deploy the defence, because there is no requirement in law for a child to prove that they've been compelled to commit an act. It is quite simply enough that the child is doing the act. And children also don't have to show that there was no realistic alternative, which adults must show. So you'll see in the absence of compulsion and a lower threshold for meeting the reasonable person test is the recognition of the unique vulnerabilities of children. So what does this statutory defence actually mean in practice? Well, interpretation has varied across law enforcement, as you would expect, and the criminal justice system. And there's no real definition that exists to agree a common understanding. But there are a couple of practical difficulties. And I'll describe 4 scenarios when the defence can be deployed. And so you may have a situation, you do commonly have a situation where police will encounter a person who has committed a crime. But before arrest of that person, they recognise that this person may be a victim of trafficking or slavery. Then the police officer will not take the matter further. Alternatively, the person is recognised as a victim of slavery or trafficking after arrest, but then before they're charged, in which case they're released. The person can raise the statutory defence after charge, but before trial. And finally, if they haven't got it at any one of these 3 points beforehand, it can be raised at trial, and not just by the advocates either. The judge has power to stop the trial and query whether or not the statutory defence applies. as the police are not consistently considering from the outset of an investigation whether the suspect could be a victim of trafficking or not, there is a huge problem, and that ties in with training. And the police, we have 43 police forces in England and Wales, and they all organise their own training. And over the last few years, I've been quite involved in trying to prepare and draft training programs and roll them out to the various police forces. Some forces are excellent in recognising trafficking, some not so. Within the Act, provision was set for individuals known as independent child trafficking advocates, and these individuals were supposed to support children if they were picked up through the process of being arrested for trafficking. Sadly, that part of the Act has not come into force. Although pilot schemes are run all over the country, still it remains a part of the statute that's not in force. I'm minded to the time here, so I'm going to not spend much more time over the children side of matters, but I'm going to respond to Rory with his supply chain information, which was brilliant. Thank you. There was a parliamentary committee review, and I gave evidence of that. And it was identified that really we did need to tighten up the requirements of the supply chain reporting requirements. And going back to my original comment, the only way you're going to get people to do things is to have a statute that tells them to do it. My recommendation, and I'm assuming others too, was that the requirement to file a report would be to say that they're doing something, not that they just thought about it, but they're not doing anything at all. And also that that reporting process would have to be tied in with the reporting requirements under the Companies Act 2006. And my suggestion was that if they failed to do it, then it would become an offence under the Directors' Disqualification Act. There have been other views expressed as to how this section and other sections in the Modern Slavery Act could be updated. Sadly, all of the recommendations are sitting in a parliamentary office drawer gathering dust, and no date has been given for these proposals to be laid before the House. Dame Sarah Thornton, in her role as Slavery Commissioner, she was Kevin Hyland's successor, wrote to various captains of industry and secretaries of state to encourage observance of Section 54, and there was a positive response in a lot of cases. However, the statistics, such as they are, still show a demonstrably large percentage of business community to whom this requirement applies who are not observant. I mean, we very clearly need a change in the law in relation to Section 54. I could go on, but I'm wondering, Lizette, if you'd like me to stop because I have reached my time limit. If I'm about to reach my time limit, before I go, I just want to tell you of one very successful prosecution in 2021, which was called Operation Fort. It was a gang, a Polish human trafficking organization and a British co-conspirator. They were convicted in June of 2021 in one of the UK's largest ever modern slavery trials, and it was believed to be one of the biggest in Europe. The victims were lured from Poland on the promise of a better life. We've heard this all before. They had appalling living conditions, threats of violence, actual violence, forced work, retention of money, and deprivation of every basic freedom. The perpetrators were all found guilty, and the sentence overall was 55 years. So we don't have a perfect Modern Slavery Act, but it is still workable, and we're still working on trying to amend it.
Thank you, Gillian. And that was a spot on, what can I say, in perfect timing. Thank you very much. And I think you provided a fantastic example that actually doesn't need summarizing. So I'll move on very, very swiftly to Marina Galles, who is our final panelist of today. Marina is an immigration lawyer and has been a member of the Barcelona Bar Association since graduating. She's a member of the Young Bars Association and the Women's Division of the Barcelona Bar. She's a teacher in the Escuela Práctica Jurídica in Immigration Studies in the Master in Administrative Law. Her legal practice has been diverse, working in different law firms, including in-house for multinational companies such as PwC and Ernst & Young. She also set up her own law firm. She was president of the Catalan Association for Immigration Professionals, and she has provided pro bono advice and legal assistance to refugees and asylum seekers for the past 5 years through the Comisión Española de Ayuda al Refugiado. At present, she is working at the Catalan government as legal technician in the General Directorate of Migration, Refugee and Anti-Racism. Over to you, Marina. Thank you.
Thank you, Lisette and Lourdes and all the people involved in this webathon. The truth is that the level and on the speeches and the panelists that were speaking before me was so high that, and they almost said everything, but I will try to do my best and try to give my speech and try to include and try to bring more issues to the debate. First of all, I wanted to just give a brief context and framework on what's the human trafficking in Spain, Catalonia, and Barcelona. Okay, and the truth is that, as always, gathering all the data is very difficult because, especially in Spain, we have different institutions that collect data, but for different purposes. We have the Spanish Intelligence Center for Counterterrorism and Organized Crime. This body just collects the data from specific indicators and just like for purely statistics proposal. Then from the other side, we have the Public Prosecutor Office that collects the data, but it's just based on the follow-up on the proceedings. And then we have the non-governmental organizations which collect the data on the support that they provide the victims. So when we want to come up with a whole picture, you just need to make a mixture and merge all this data. But anyway, the truth is that this is an increasing issue that all the different institutions and organizations are taking care of, and they try to provide this wide approach. In fact, for me, it's always better to go and look the State Department of the EU, of the United States, because they really collect the big picture and all the data. Okay, and according to them, Spain initiated prosecutions for 64 suspects, 40 for sex trafficking and 20 for labor trafficking. Okay, that's data from 2021. Okay, which means it's 2020. Okay, this means that basically, as all of you mentioned, the pandemic situation had an impact, of course, but the truth is that it was not that high impact. It didn't stop. I mean, all these crimes and all this human trafficking activity didn't stop during the lockdown. In fact, some studies even highlight that women in prostitution had even to move their activities to private apartments, which, as you can imagine, this put all these women in a more vulnerable situation. And And the main reason for this was the lack of income and inability to pay the rent. So this was even a worse situation that the pandemic led to all these women. Further on this context, I also wanted to mention that at the Catalan level, Mossos d'Esquadra, which is the national police from Catalonia, carried out 10 police investigations. That was in 2021. And in July 2022, there were still 9 open investigations. This means that between 2016 and 2022, 51 victims of human trafficking for labor and sexual exploited have been detected and have been with a follow-up of the police. Okay, and then at the local level, we have the data of the human trafficking unit. I will explain to you later. Okay, and they tell us that during 2021, 229 victims were in their unit. Okay, and the victim profile for these victims is always corresponds to a woman aged from 20 to 40 years, and the main nationalities is from Nigeria, Colombia, and Venezuela. Okay, so having said so, we need to go to the regulatory framework. Okay, I will start from Spain again. Basically, all the regulatory legislation, laws, and other protocols, they are all based in the penal code, and we have the Article 175 bis, which is like the core value, and then apart from this, all the rest of the regulations they start their work. Okay. It's quite good and well detailed article, okay. And the best thing is that it highlights different kind of human trafficking. So, and what the penal code says is that it applies in cases of forced labor, slavery, or any practice similar to slavery, servitude, and also begging. This is like the first one, but we also have sexual exploitation, including pornography, the exploitation to carry out criminal activities, also the removal of organs, and also the celebration of forced marriages. So it is a very detailed article, which then also explains the rest of the legislations that we have in Spain. So other laws, there is a very big list. We have a framework protocol on certain actions and relation, especially to unaccompanied foreign minors. There is also a comprehensive plan, which was from 2015-2018. We also have the asylum law that refers to human trafficking, foreign law that also refers to this, and other instructions and plans. But what I will tackle at the end of my intervention is the new draft bill, which tries to be a comprehensive and tries to put all together all the issues regarding trafficking and exploitation of human beings. This is from the Spanish side. From the Catalan side, there are different resolutions from the parliament regarding the human trafficking. We also have the law on equality for men and women. And there is also a plan for international protection in Catalonia, different protocols, and also the law for women also refers to human trafficking. And then at the local level, as I said before, we have the municipal unit against human trafficking. which is a body at the local level that provides anybody who is victim of this crime, either if it's minors or adults, it provides comprehensive care, which means that they can have advice from different professionals, and not only for the victims, but also for the victims circle, meaning all the people who relates to the victim. It is a very open organ or body. Anybody who has been victim can refer, as I said, minors and adults, but also if the exploitation took place in Barcelona or abroad, people who is living in Barcelona or used to live or can any way be related or registered in Barcelona can also access this unit, okay? And it's anyone who has been with any sign of being exploited. It doesn't need to be formally identified as victim of human trafficking. And this, as you can imagine, is very important. And last but not least, it's also people, regardless of their legal situation, even though people who has not regular status in Barcelona or in Spain, they can also access this unit, which will provide advice from professionals, social assistance, psychological assistance, legal assistance and representation, and also safe shelter in coordination also with our specialist services. Okay, that's from to give you the final framework. Okay, and sorry, I'm trying to go very fast so we can have a little talk later. Then in my last minutes will be to talk about this draft, this new bill that is being still in discussion, but there are already some things that we can highlight. The first thing to highlight is that it's a good law in the sense that it really comprehends all the issues and really puts in just one page all the issues related to human trafficking. But what is good is that beyond the criminal response, it also includes the prevention and awareness raising in the society. That's also good because it brings a series of rights and support measures. Okay. What is really new in this law is that there will be a national referral mechanism, Mecanismo Nacional de Detección, which it's a body that is created for immediate referral of alleged victims of trafficking. This is a good idea, although according to different recommendations on international organizations, it should be better if it could be an independent body. Okay, Lisa told me that it's time to go, but okay, I just wanted to tell you that it's a very comprehensive law, which also contemplates the protection of minors. There is a very big protection system, and there is also a creation of the national rapporteurship against trafficking and exploitation of human beings. And the only thing is that we should work more on the detection and identification of victims, because although this law really allows to start some processes without the formal identification, it is true that Spain lacks a little on the detection and identification of victims. And that's all. Thank you very much, especially to all the other panelists.
Thank you, Marina, and thank you all for your fantastic presentations. I'm afraid this is going to be it from us. It has been absolutely fantastic. I have learned quite a lot. And on that note, I will be handing over to Lourdes so that she can give us a few instructions for the next session. Thank you.
Thank you very much, Lisette, for this excellent moderation, and thank you to Marina, Rory, Mr. Shi with his excellent keynote speaker, and Ken representing him, and thank you also Gillian and everyone. You know, Professor Eric Biel, it was great, and in the interest of time, I just have to emphasize the role of lawyers, you know, and whatever work we can do to change this high profit low risk incentive for traffickers, you know, given the nature of the crime, and with effective prosecution and protection of victims will in turn protect survivors and ensure them access to justice. So I just wanted to say that, and before saying goodbye, invite you to the next panel. You know, thank you for joining us for this panel, and our unprecedented rule of law webathon does not stop here. I would like you to join us at the top of the hour, which is now at the IABA panel on counterterrorism, human rights, and the rule of law. Thank you.